You know, I get questions from the pro say, what should I do? Should I do this or should I do that? And of course, you know what my fallback answer is? Always look at your facts and the law to help you make that determination. But I thought it would be fun to do a video on things that you should not do or should do in certain circumstances. And I have 11 of them. This ought to be fun, but informative, so let's get started.
Why you should memorialize your communications. The pro se sued her employer for discrimination. Prior to the lawsuit, the supervisor admitted that the employee who was a subject to the lawsuit had been previously verbally reprimanded by her for discrimination. However, during the supervisor's deposition, she was asked that question and she denied that she ever said that. So now it becomes a matter of he said, she said, when an email memorializing their conversation would have been on record, thereby empowering a pretext argument and even used for impeachment purposes. Why you should not disclose your documents outside of formal discovery. A pro se wrote me and said that the defendants filed a motion to dismiss, and they asked her to show them a recording that she wanted to use as evidence. She wanted to know if she should give the defendants her recording. Well, one, the document is not on the record, and the document potentially loses any protection, for example, from privilege or the power to impeach an individual's testimony. Remember, there are two instances when the pro se is required to disclose documents or information. It's during the initial disclosures. Federal Rules of Civil Procedure 26. And during the court appointed discovery. And what I'm referring to here is when the parties meet with the judge and finalize the scheduling order. In that order, remember, the parties will discuss discovery, when it starts, when it ends, so on and so forth. Why you should send a demand letter to the defendant. The facts and the law are on your side. In other words, the facts and the law strongly support the prima facie elements for the cause of action. And don't forget, you want to conduct research to find comparable cases that would enhance your demand letter. Give enough to test defendants' interests. Be careful not to disclose your legal theories and information that falls outside the initial disclosure period and discovery. Remember, sending a demand letter is voluntary. Why you should take witness depositions. Now, this is where counseling and listening skills come into play. You should listen out for not what the witness is saying, but what the witness is not saying. And another advantage to depositions, unlike interrogatories, you can follow up on the witness's question immediately and the opposing counsel's follow-up questions to the witness. Why you should not delay taking discovery. First of all, you're going to get so much time to conduct discovery. And that is going to be ordered in the scheduling order. Often, I find litigants will conduct discovery almost during the end of the time allotted. Please don't do that, because if you're towards the end of the discovery and you ask the court to give you more time, the court is going to look at your good faith effort. And especially if you ask defendant to an extension of time, they may argue that you should not be given that time because you did not make a good faith effort to conduct discovery. Why you should waive formal process of service. Now, this is a lengthy discussion. So instead, what I want you to do is go to Federal Rules, Civil Procedure 4 regarding summons and read upon it and get familiarized with it. But let me just identify some things about this process of service which would be advantageous to the pro se or the litigant. It's cost efficient. It encourages, or let me say, the court encourages the defendant to accept the service. My experience has been that the defendant is less likely to evade service. Another advantage is it gives the defendant more time to respond to the complaint. As a result, it gives the pro se or the litigant additional time to just review the case before the real litigation begins. Why you should not argue against defendant's request for an extension. For one thing, you are likely going to need an extension yourself. So you're going to have to go to the defendant and ask them to consent. Two, the court is likely to grant it anyway. Three, the court appreciates it when parties cooperate with each other. Now, I'm sure there are other grounds for not arguing. Absent some conduct of the defendant that would harm your case, grant the extension. Why you should not bring your notes with you to your deposition. Immediately, two things come to mind. Defendant will ask to review them, and the defendant will use those notes to question you at the deposition. Why you should not discuss your case with a non-attorney. The communication could potentially waive privilege and confidentiality, and the individual, the non-attorney who heard the communication or participated in the communication, could be called as a witness at a deposition or at a trial. Be careful about that. Why you should not argue with opposing counsel. For one thing, it's not worth it. Trust me on that. And two, you want to keep your blood pressure down and stay focused. Why you should represent yourself. You know your case. You know its facts. You know the law related to your case. You can establish the prima facie elements in your case to avoid a motion to dismiss. You've located case law to support your position. And lastly, the law gives you the right to represent yourself. So relax and be